period of about, I think it was 4 months, if not 5 months. Then the commissioners' courts were abolished. We all became additional magistrates after that.
All right. And you joined the magistracy and worked your way through that office as additional magistrate for a period of 12 years.
Yes.
What kind of work did you do during that period? Criminal or
criminal work, civil work, quasi-judicial work. In fact, at the beginning, as you would see in my CV, we would also do administrative work, supervising the supporting staff, because at the time, the departments had not been separated. We still had labor courts, and, labor, family courts, all those divisions that were later separated from the Department of Justice. So at the time, the work that I did was not just being a magistrate.
Yeah.
You do almost everything in the office.
Then you became a regional magistrate in 1998 and remained in that position for 13 years,
Yes.
says, until you became a judge of the High Court in 2011.
Yes.
Your application form is not specific. Does 2011 reflect the date of permanent appointment?
It is, yes.
Okay. Had you acted as a judge before that
I
time?
acted from 2010.
From 2010. For how long?
I think it was for 3 or 4 terms.
Almost the whole year.
Yes.
All right. So that would mean then you have about 4 years judicial experience as a High Court judge under your belt, including
Yes.
the acting stint. All right. You've done a whole lot of other things. First, before I get there, you've acted as a deputy judge president.
I have for
how long?
Last year it was for 1 term, and this year for 1 session.
Okay. And what kind of tasks did you perform to assist the judge president during those 2 stints?
Well, I performed all the functions the judge president is supposed to perform, starting from the bottom, preparing rosters and allocating work to judges, dealing with administration, dealing with all the complaints that are brought to the division.
And the judge president was satisfied with your performance?
I think so, because...
Or is it for her to say?
Because she never complained, and I received a positive feedback.
All right. I see that you have a whole bag full of other skills that would be useful in a leadership position. You've listed 2 pages worth of all the training sessions you've undergone, and those importantly include a leadership course you did in, first a workshop on case flow management in 2005. Then you did a leadership course in 2007.
Yes.
And then more recently, but not so recent, in 2015, you attended a seminar on judicial case management, amongst other subjects that were that were offered during that seminar. Did you find those that experience useful? Do you think those skills would assist if you were lucky enough to get appointed for this position?
Particularly when it comes to case flow management, because we cannot talk of quality access to justice without an effective and efficient case flow management.
Yeah. All right. I'm not going to ask you about the judgments you've written in your 14 years as a judge. All the professional bodies have spoken highly.
Yes.
They commend you highly for the quality of work you produce.
Thank you.
On what they say is the widest legal spectrum.
Yes.
I just want you to tell us as briefly as you can what plans you may have to improve the efficiency of the division's operations in collaboration with the judge president in this position, if you get it. Challenges you may have identified and propose solutions. But as you do that, I would ask you to keep in mind, just take into consideration Saula's request to us. I can't find it now, I'm sorry. But they wanted, you would have read the papers, they wanted us to question you closely on what benefits you would bring into this leadership position. So if you could just take us through your vision.
The division has lost many senior judges, and we had to make do with acting judges most of the time. So the first thing that should happen is we should appoint more permanent judges, because there are problems with acting judges in the long run, because they have other private engagements, and that sometimes may cause a delay in finalizing some of the matters. We also have an extensive caseload. I think we would need to have more judges to help deal with those matters expediently. We have a problem with the RAF matters. The lead time, I think we are now in 2027. We're about to go to 2028. So that's the problem I've noticed as I was acting, that we need to deal with those, with RAF roles. Now, the way I look at it, what I've noticed is that the problem in resolving these matters speedily is not about so much about the complexity of these matters, but it's about the time that both litigants need to discuss these matters. What I've noticed is that if you give them time, either during the case flow management or during the RAF role, which we used to have, and in that role, I would give them time or a date to talk, and if they talk, 90% of those matters are resolved. And they advised me that it's just the time to get together to discuss these matters that they need. Now, that would help us with the lead times for trial matters, because most matters will be settled. I think that's about all that I can mention now. But we still have to also to improve on our pre-trial conferences, because that would also help to finalize matters speedily. If it is effective and efficient, that should help us to finalize matters speedily. We have done, I chair the Court Performance Committee, and I've identified those problems that, as to where the problems lie and as to what should be done to alleviate delays. Because in particular, criminal matters, you get many problems pertaining to counsel not being available, or counsel that was there withdrawing and another one taking over. That also delays the proceedings. The same thing applies to civil matters. As I say, I try to give them more time in court to resolve those matters. And if they can't, only then can one look for a date to set down the matter for a hearing. But I'm talking about RAF matters, but most of those matters can be resolved without a trial.
I've found the solar commentary, and you've answered half of what they wanted us to raise with you, but they ask that you be questioned on how you would effectively use mediation in the context of increasing litigation against available resources in terms of courts and the number of judges, which you've lamented. Have you had occasion to use mediation in resolving matters?
Let me put it this way, sorry.
What is your view on mediation? Let's start there.
Parties do approach me in chambers and tell me what is the dispute between them. And sometimes I indicate to them that if the problem is this specific problem, perhaps the best way of resolving it is that way. If they can't resolve it, obviously I have to resolve it myself. Usually it is narrow issues that they actually want resolved. But I always encourage parties to mediate, even during case flow management, that the parties should go and talk. If they can't talk or don't agree, maybe find a mediator to do so on their behalf. But I've noticed that without finding an outside mediator, they are actually able to resolve the issues in those matters.
All right. You listed a reserve judgment in your application form, which you undertook to deliver shortly after you submitted the form. Was it delivered?
Yes, no, it was delivered at end of June, beginning of July.
All right. One last thing for now. A concern that has been raised by two professional bodies, the BLA and NATEL, concerns your age, which they term advanced. How old are you?
66.
Should that be held against you?
I don't think so, because there's a lot that one can achieve in 4 years' time. The programs and projects that we may introduce to improve access to justice are not things that would take forever to be implemented, are things that we would discuss and implement immediately, and that should benefit the division. So also maybe I should mention that it would not be a bad thing to balance the gender scale. I get on well with the JP. She's actually a good head and a good heart. I think I also have those attributes. We should be complementing each other very well if I'm bound to be fit to be appointed as the Deputy Judge President.
All right, just one last aspect I did not cover. You initiated and led a project to establish an intermediary room in the Sexual Offences Court in Scotsburg.
Yes, that was whilst I was a regional magistrate there,
Yes.
and it is still operational.
Where did you get that idea from?
Sorry?
Where did you get that brilliant idea from?
It was in my court. I could see that only all tables were put there in that room, and I thought, this is not good for children. I should ask some of my colleagues for help, the local business people to help. I also got an artist to decorate the walls and others to donate dolls and things like that in the room, you know, just to lighten up the mood for the children when they get there. Still working till today. I'm happy to say that sometimes if I do go there, I see that it's still working very well.
Good to hear. All right, I'll hand over to the Judge President to put questions to you, if she has any, that is.
Thank you, Chief Justice. Yes, thank you. I do have. Good morning, Judge Nkosi.
Good morning, JP.
Yes, I do confirm we work well together, and I have not received any complaints about you. And also, when I was perusing your papers, I saw that I'm younger than your firstborn, but I have never felt that way. You have treated me with the respect that the office requires, and I appreciate that.
Yes.
Yes. Just on the reserve judgments, I see that your name had appeared previously 2021, 2022 on the list. But after my appointment as the JP, that is 2023, I haven't seen your name appearing on a list for more than 6 months or so. Is that correct?
Yes, that's correct, JP.
Yes, yes. And the one that was taking longer for you to do was the inquest, and you asked for time out. If I recall, you were due to go on leave, but you postponed it so that you can deal with the judgment.
That's right. In fact, it was at the time I was acting as a DJP that I delivered it.
Yes.
But I needed time before that in anticipation that I would be quite busy as the ADJP. That's why I needed that week to prepare the judgment.
Yes, thank you. Now, you've mentioned when the CJ was asking you certain questions about some of the challenges that we have in the division, particularly the RAF and some of the criminal matters. Just on the criminal matters, what's your view? Do you think we have a backlog or we don't have a backlog?
We do have a backlog, especially on circuits. The last time I was there, I had about 4 or 5 backlog matters. I managed to deal with 3 of them and finish them. Others had to be adjourned because either council was not change of council. So a new council had to take over. But at least I managed to do 3 and finish them. But we do have a backlog. I think if we get a division in Richards Bay, where we would have 2 criminal courts maybe and 2 civil courts, and maybe another deputy judge president heading that division, that will go a long way in bringing justice to people of that area, especially with regard to criminal matters. I know we don't have too many civil matters coming from that area, but who knows what might happen if we open that court and people know that justice is just next door to them. We may get more civil matters coming from that area.
Thank you. Then on the RAF matters, any practical suggestions on how you would, if you were appointed, you would deal with the issue of trying to alleviate and try to shorten the lead time, which you have correctly said is about 2027 for now for trial?
The only way to deal with that would be to do a proper case flow management. As I say, to encourage parties to discuss the matter and see where they differ, where the differences are, and try and resolve it. Because until we get more judges, which I'm hoping we might get in the near future, we'll have to make do with the only judges we have. And just improve on what we're doing. Make sure that we finalize matters as soon as possible. No unnecessary delays. I think for now, that's the only way we can try and, address. Because if matters are finalized, obviously spaces do open, and then new matters can be dealt with.
Yes. Then just on the reserve, the parted matter, and Ikaluza and the Minister of Police, I see that it's due to continue from 21 October, but when had it started?
I think it started last year. No, in November, I think we started it last year.
All right. And I note what you have stated about supervising some of the staff matters of the staff, because this is a managerial and a leadership position. Any other managerial or leadership skills that you have other than those?
Yes. Obviously, I managed the work of magistrates before. It was not just about the supporting staff. I'm talking about criminal and civil matters when I was still a magistrate. I also I was a training officer, training magistrate and prosecutors and support staff. Now, that needs managerial skills. But I have also, now that you gave me the opportunity, I have also learned how to manage things, personnel, work in the High Court.
Yes. Just on the one for supervising magistrates, particularly the regional court, because you were a regional court magistrate.
Yes.
We have a problem with the finalization rate and also the court hours. How was it then when you were a magistrate, and what helped to try to, if there was a maximum sitting period, what helped you to get to that? Because now we battle to get 1.5 hours on average a month.
Well, with the regional court, especially those who are not based at the center in Durban, because we were all based at Durban Center, and then we are assigned to different regional courts to perform our functions. You do that, you control everything there on your own. I didn't have too much of a problem at the time in my regional court, but I see that at the time the emphasis was not on case flow management, an effective and efficient case flow management. So we did have that conference with them, and we emphasized case flow, effective case flow management, and because the president was also there, was also involved. So I think sometimes magistrates allow matters to be adjourned easily. I say sometimes. One would not know why the matters are adjourned and people sit only for 1.5 hours. But it comes back to the effective and efficient case flow management. If you do it correctly at the beginning, you should be able to deal with those matters and finalize them speedily. You do get those long ones, long matters that may take time. But if you have done the planning correctly at the beginning, you should be able to finalize those cases within reasonable time.
Thank you. And then I think just 2 more questions. One about Dr. Ghani. The one that I'm concerned about is the one where she says you treated a white male counsel differently to a black counsel that appeared before you. What's your comment to that? I don't know whether in relation to that one matter that she's complaining about.
A white male counsel,
Yes,
and the other one was black.
yes.
No, it was both white counsel. The one was a lady, and just for her information, I must say that I actually worship the ground she walks on, that lady walks on, because she thought maybe I didn't treat her well, but that was not so. I treated them equally, but the unfortunate part is that the party involved was her son. So maybe that is why she thought, you know, I was being hard on the lady who was counsel for her son. But I treat everybody equally. You can ask any other person who knows me, they'll confirm what I'm saying. So I do not know where that comes from. Maybe it's because she was emotionally involved in the matter.
Yes. And then lastly, with regard to the comments by Saula about the gender, that your appointment would not advance gender transformation.
Yes.
on the bench. And your comment partly was it would balance the gender representativity. It probably would also balance the age representativity.
I think so, yes.
Yes, but in light of the fact that there are now two male candidates, being yourself and Judge Cili, what's your comment on that? Is there any comment that you have?
Well, if Judge Cili is the best candidate, please recommend him. If I'm the best candidate, I'll be happy to be recommended. So I do not have a problem with Judge Cili being involved as well. Obviously, it is your decision. You decide who would fit the post best under the circumstances.
Thank you. It is the decision of this body, not mine. Thank you, Judge Nkosi.
Thank you, JP. Do you have questions for the candidate, Premier?
Thank you, Chief Justice. I do have a question. Good day, Judge Nkosi.
Good day, Premier.
No, I just have a general question to understand you better.
Yes.
You have acted as the Deputy Judge President in the province. I just want to understand your noticeable or remarkable inputs to the division during your acting, and wish to understand how do you think that can assist the division in the future. The noticeable, if there are any noticeable or remarkable inputs in the division.
Well, the inputs will be general inputs that I expected of a Deputy Judge President. Working hard, being up to date in everything, making sure that courts are functioning properly, everybody is on board. I did all of that, and it worked. And everybody was happy to have me on board. I'm not going to quote anybody, but everybody was happy to have me on board. Other things still have to work through them to improve access to courts, finalizing things quickly. Also how you accept members of the public. People are happy because that's who I am. So I don't think there could be anything more than what is expected of a Deputy Judge President to do correctly. I think I did all that. I don't know if I've answered your question.
No, I hope so. Thank you, Chief Justice.
Thank you, Premier. Do you have questions for the candidate colleagues? Commissioner Nkosi?
Thank you, CJ, and good afternoon, Judge Nkosi.
Good afternoon, Commissioner Nkosi.
Yeah, to be fair, let me ask you the same question I asked from Judge Cili. Can you talk on the importance of relations between judges, staff, and the other stakeholders?
The importance of?
The importance of the relations between staff and the stakeholders.
There should be harmony. I think we are the strongest when there is harmony. is very important. There's very little you'll do if there's no harmony. So I am the type of a person who makes sure there is harmony
Yeah.
and that work is done.
Yeah, I just want you to comment on this. Unfortunately, when I was there in KZN, you were not there.
I understand you were in Peter Marisbeek, I was in Durban.
Yeah. I find something unique for KZN where judges on Thursday would come together,
Collegiality, yes.
have lunch and all that. How that enhances the relations among judges themselves, and how does it strengthen the unity of the division, and how, yes, that's the first part of the question. The last part of the question is, Judge Trilly had indicated that at some stage there was disunity in the division. Do you confirm that? If you do, what is the position now?
Well, I don't know if I should call it disunity. And I'm not sure during what period there was this disunity. Perhaps,
Before the coming of the current JP.
oh yes. Well, very few individuals were involved in that. Very few individuals were involved, and I think one of them did sit here during those interviews. Other than that, there was not so much disunity. It's just individual, who maybe had a preferred candidate, I do not know. But I tried not to get involved in such things.
Thank you, CJ. Thank you. That's all
Thank
from me.
you, Commissioner Nkosi. Just to follow up on your last comment, Judge Nkosi, you say you don't get involved in such issues. What do you mean by that?
So, if somebody says, I like this candidate and not this candidate, I always avoid engaging people on those topics, because it's not a question of whether you like the candidate or you don't like the candidate. So I supported both candidates at the time. I didn't choose sides. This is what I mean.
All right. So you reference only in one example. Was that the only source of disunity? That there were two candidates?
As far as I know, that was the only source.
All right. But I raised this question because you are applying for a leadership position, and if there is trouble in the division, then it would be your responsibility, resting squarely on your shoulders, to deal with such issues immediately.
Agreed.
And not avoid them.
Agreed, CJ.
Okay.
But collegiality, I always promote collegiality, even amongst those who don't agree.
All right. That comforts me. Thank you, Judge. Commissioner Nkosi?
Yes, good morning, Judge Nkosi.
Good morning, Commissioner Toby.
Yes, now it's just to follow up on the exchange you had with the Judge President, particularly on that objection by Ghani.
Yes.
Yes. So I hear your point that you worship the ground on which Advocate Julian walks. But I think the real issue is whether you respect her as an advocate in the equal way with the male advocates, because I don't think advocates are interested in whether judges worship the ground on which they walk. What they want is to be treated with respect.
Yes,
That's the nub of the issue. Can you just assure us on that issue?
Oh, yes. I'm a very respectful person. Very respectful. I would never treat people differently because of who they are. In terms of gender, in terms of race, in terms of religion. So that's why I said I worship the ground she walks on, because I wanted to make a strong statement that I would never have done so with her. She's a very brilliant counsel, very brilliant. And I would never discriminate against her at all.
All right, that's fine. I mean, that's your answer to the objection. Then there is a second part to that objection, which is that you gave an order, I think it's on the 17th of August, 2023 in open court. A request was then made for a written order and a follow-up to the office of the judge president in March 2024. Nothing happened. It only surfaced on the, I think sometime in July 2024, which then frustrated their ability to ask for leave to appeal, which implicates you now as a DJP in delays, as an aspirant DJP in delays. How do you answer that part of the objection?
No, I think the order they were asking for pertain to a divorce decree. It was not an interlocutory order that I granted last 2023. Was it 2022? I think I started that matter.
No, this one is 17th October 2023. But in your response, just to help you, you admit that there was a delay, but you say that it was not your fault. It was at the registrar's office.
Oh, yes. Oh, yeah. Yes. I think that was the final order, if I'm not mistaken. Was that not the final order? If I remember, it was the final order, which should have been.
But when your response says the required date, this required a date convenient to all the parties, the first being the 2nd of March 2023, oral submissions were made on the 14th of March 2023, and the judgment was handed down on 17 October 2023, just outside of the 6 months norm because of a hectic acting stint I had as an acting DJP. A significant issue of an extended delay in issuing the court order following upon the delivery of 17 October 2023 is also raised. So that is what you admit, and then you say, but
Oh, yes.
they should not have asked me, they should have asked the administrative people.
Yeah. No, what should have happened there, once the judgment had been given and the order granted, the attorney who represented the party should have approached the registrar for the order to be typed. Now, such complaints are usually dealt with at that administrative level. Nobody ever came back to me to say, by the way, judgment is out, we have still not received the order, in which instance I would have asked my registrar to check and help them to find out where is the delay.
Yes, except that they accuse you of being obstructive in the obtaining of the order, which implies that they did
It
tell
was
you.
incorrect of them to do so. It's not a judge's function. It's not a judge's function to issue orders. I mean to make sure parties get orders. I had finished my part, gave judgment with the order. All that the attorney for the party should have done was to approach the registrar to get the order typed.
Yes, look, I'm sorry about this. They say, look, you've given an order, ex tempore, fine. We've then asked you for the written order and then you disappeared on us.
No, no, that is incorrect. The facts are incorrect.
Yes, no, that's what you say in your response, but I'm just giving you a chance to
Okay.
elucidate to us.
Okay, no, that is incorrect. I never gave any extempore judgment in that matter, save at the beginning of the hearing, of the trial. Because that related to the access rights. So I gave that order, extempore, yes, extempore, before we started the trial. And there was never an indication that anybody wanted to appeal. It was not appealable anyway. It was an interlocutory order, which was not appealable because it only related to the access rights to the child, whilst the trial is running. So I didn't understand the complainant to be referring to that order.
Yes, but I thought that you and the complainant are at idem, that there is a judgment or an order you gave on the 17th of October. They asked for a written document proving it. You were nowhere to be found.
Oh,
And then you then say in your response, it was not my job, it was the administrative staff.
no. I thought she was referring to the last order that I made. And they applied for leave to appeal, as you know. And I granted that. No, I didn't grant the leave to appeal, but there was one issue that is still outstanding in that matter, which relates to costs. And I know that matter is still sub judice because they are likely going to the SCA.
Right. Just a last point on this. I mean, what I'm really trying to get to is an explanation of the delay between October 2023 and July 2024 in them getting a document from the court. Whether you're saying, well, that's true, but it's not my problem, it's someone else's problem, or it's not true. I'm just trying to,
No.
I'm not trying to catch you, I'm just trying to, you
Okay.
to give an explanation.
All right. Actually, I heard about that delay for the first time when the complaint was sent to me. I didn't know anything about that
In these
delay.
proceedings, in this interview.
Yes.
Okay.
Nobody ever approached me about any delay. So I would have helped if somebody approached me, although it was attorney's job to approach the registrar, but I would have helped because I always do help parties who need help. That is part of my job.
So the real answer is it didn't come to your attention.
Sorry?
The real answer is it didn't come to your attention. It's not this thing that it was not your problem, but just no one brought it to your attention. That's the real answer.
I just didn't understand how an attorney would not approach the registrar to get the order. And I'm only hearing it for the first time because of this interview. So I just didn't understand how it happened. And unfortunately, as I said, nobody approached me to say, Judge, please help us. The registrar is not helping us with this, to type this order or to issue it because it is issued by them.
Thank you, Sir.
CJ, may
Thanks,
I follow
Commissioner.
up, please?
All right, let me just ask mine first. Just really, I'm sorry, I missed part of I got distracted. I missed part of the engagement you had with Commissioner Nkosi. Do you say you handed down this order in open court?
Yes,
So it was only the typing and the
that's
admin
right.
side of it that was outstanding?
That's right.
All right. No, that edifies my concern. But I just still want to raise something with you. You made a comment that you had done your part. Now it was for somebody else to ensure that the order was disseminated to the party or the parties. But I just want to caution you that you're applying for a leadership position, and ultimately the buck about everything that happens in that division rests at your door,
Yes.
your and the JP's door. So it is your responsibility. If there are failures in the registrar's office, for example, when parties complain, you're not going to point fingers at the registrar. You should have measures in place to
Yes.
ensure that the registrar and whoever, all the the administration staff, actually perform their duties.
Yes.
And it's just your duty to
Okay.
do that.
Yes. Unfortunately, I was not aware of this complaint. I always
But you
attend.
do realize that when you assume a leadership position, you will assume the duty to ensure that those orders are actually
Certainly.
sent to the parties.
Certainly, CJ.
You understand that?
Yes, no, I do.
All right. Well, that's what judges do at the Constitutional Court. We have the staff who is paid to do that job, but things fall through the cracks, and you can't afford that.
Yes.
So the responsibility rests on us to ensure that the court does its work to finality properly.
Yes.
Okay. JP Mlambo.
Thank you, CJ. Good afternoon, Judge Nkosi.
Good afternoon, JP.
This is just a follow-up on this line of questioning, but the CJ has partly covered me. But what I want to check is, when you acted as DJP, didn't you have occasion to check the turnaround times in terms of which parties get their orders? Let me give you the context. In Gauteng, the turnaround time is 7 days. We have an electronic management system, and the secretaries, judges' secretaries know, and their judges know, that all orders granted in their courts have to be uploaded and provided to the parties not later than 7 days. So I'm just asking you, during your stint as acting DJP, whether you had occasion to look at this or whether you have a system.
We unfortunately do not have a system in that division. But I suppose I'll have to, if you find that I'm the candidate for the position, I'll have to implement that.
Okay, thank you, CJ.
JP?
Thank you, CJ. I am covered, but just for certainty, Judge Nkosi, I wanted to confirm, to just check with you in the ordinary course. Once you have granted an order as a judge, what happens then?
Well, the file is taken to the typist to type the order,
Yes.
so that when an attorney phones to find out whether the order is ready, has been issued, they can then come and collect it.
And as you say, if you were aware that there was an issue with the order, you would have assisted.
I would have sent my registrar or secretary to go and check and solve that problem.
Yes, and just to confirm, CJ, also, I saw my name is mentioned in that letter. I never saw that complaint as well
Yes.
on my desk about this order.
Yes.
Thank you, CJ.
Thank you, JP. So it rests on the parties to collect the order from the court. The registrar does not send the orders to parties.
Well, it depends on the arrangement between the register. It goes to be typed, and then it is issued. I do not know if they send it to the parties or the attorneys come and collect it. I'm not so sure
You're not
about.
sure. And in the case of a party, a self-representing party, do you know what happens?
Sorry?
In the case of a party that represents themselves, what happens? Where there's no attorney.
Yes. So that's why I say, if I am appointed a DJP, I'll make sure that that process is streamlined.
Yes, clearly there's a gap in the
Yes.
systems. And the court has actually, it has a duty to send its orders to the parties.
Yes.
If the parties choose to make its work lighter by collecting them, that's
Yeah.
fine. But the registrar should dispatch orders to the parties.
Yes, no, I agree.
Thank you, DJP. Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Judge Nkosi.
Good afternoon, Commissioner.
Judge, on my calculation, you've been a judge for 13 years now.
Yes.
Can I ask you to look at paragraph 16 of your questionnaire,
16.
1-6, and you'll find that at page 10.
Yes.
You ask there at 16.1, Judge, to list the cases where you have written the judgment which you regard as being the most significant. And it stated not more than 10. But you only provide, you're one of the unusual applicants that only provide 8 cases.
I could have given more. I read somewhere that they mentioned about not less than 3 or something like that. So I thought maybe 8 cases would do.
So we are not to deduce from that you only have 8 significant judgments.
Oh, no, there there's many more.
All right.
As you can see from the SAFILI list that is also attached. No, I didn't attach it. There are actually many more that are on SAFILI.
So I just want to tell you that the immediate impression or the concern that jumped out at me when I read this was one about work rate.
Oh, okay, no.
And it was calcified by your next answer, which the question is, which of these cases have been reported? And you indicate that only one of your judgments have been reported. Or is it
Yes.
only one of the 8?
Only one of the 8. There was another one reported. I don't know why it doesn't show, but it's the matter that was decided by the full court of the Mpumalanga. They obviously overruled my judgment. So that is why it doesn't appear here.
So how many reported cases do you have?
Oh, it's
there?
only 2.
You've got 2 reported cases.
Yes.
Then, if you look further on, you asked at 16.3 and 16.4 to list the cases, list the judgments which were unsuccessfully appealed in 16.3, and you say none.
Yes.
And in 16.4, you asked to list the cases where you your judgments which were successfully appealed, and you say none.
No, this was not an appeal. It's another division. Full court of another decision changed my decision.
No, I accept that, but what the questionnaire is asking you is to list which of your judgments were successfully appealed and which of your judgments were unsuccessfully appealed. And in relation to both questions, you answer none.
Yes, because none were successfully appealed.
So in 13 years, not one of your judgments have been appealed?
No. Well, some, I do not know, because judges are not told which matters went on appeal, which ones. They are supposed to be told, but we only hear when the matter returns, either from the SCA or from the Constitutional Court, as to the outcome of the matter. but I'm not aware of any.
And unsuccessfully appealed?
Well, sometimes none were unsuccessfully appealed because sometimes a judge would never know which matters did eventually go on appeal.
I'm so confused, Judge, because you're now saying none are successfully appealed and none are unsuccessfully appealed.
Yes.
In how many of your matters have you granted leave to appeal?
Well, I don't remember, but quite a few. Very few.
Over the 13 years, very few
Yes.
leave to appeals.
Very few, because parties, that doesn't stop the parties eventually to go on appeal if they want to seek a special leave to appeal. But of those that I allowed to go on appeal for a good reason, none were successfully appealed.
So all of the appeals were dismissed?
Sorry?
All of the appeals were dismissed?
Yes.
But that does mean that your answer is incorrect when it asks you how many of your judgments were unsuccessfully appealed.
Well, yes, I think maybe the question was not very clear to me.
In the questionnaire or my question?
No.
Oh.
I'm talking about the question here that, yeah, if I remember well, I think the PLA, not the PLA, did mention one matter which went to the SCA, which that was in 2013, I think. When I was still a young judge, I'd forgotten about that matter.
So just a final question, Judge. In your division, is it not unusual to only have 2 reported decisions in 13 years? 2 reported judgments in 13 years?
No, it is not. It is not, because we usually send matters for reporting which raises a novel issue or a new issue, or which explains another issue which may not have been clear before. And how we do it, all our prepared judgments, reserved judgments, we give them to the people who look into our judgments, who correct them, and their senior receives those matters and make them available to the reporting houses to see whether should this judgment be reported or not.
Thank you, CJ.
Thank you, Commissioner Pillay. Any more questions? Oh, sorry, there's Deputy Zondi first.
All right, thank you, CJ. Good afternoon, Judge Nkosi.
Good afternoon, President.
I've just got one question and just a comment. The first question arises out of your engagement with Commissioner Pillay. Now, regarding your judgment that have been appealed against, successful appeal against, and then in your statement you said the judge will not know which matters go on appeal, but surely before a litigant can take the matter on appeal, that litigant will have to approach you and apply for leave to appeal. Is that not so?
Yes, that's true.
So obviously, then you would know that this matter, I granted leave on this matter, or if you refuse leave,
Yes.
then that's it.
Yes.
Okay. And then my second question relates to the issues which you identified as challenges in your court. Now, those issues or those challenges and the manner in which you want to address them, is it part and parcel of the vision of your JP? Remember, you'll be reporting to the JPA and you'll be doing whatever the JPA has assigned to you. So your vision must be aligned with the vision of the JPA.
Yes,
So that's what I wanted to establish here.
Yes,
The
no.
things that you have just outlined to us, that is the problem arising out of the late delay of judgment by the acting judges, the backlog, RAF matters, the pre-trial conferences. Is it part and parcel of the vision of the JP and you share that vision?
yes, it is.
Okay, and then just my last comment just relates to the manner in which you handle the reopening of the inquest of Dr. Hafaji, and hopefully the mother, although I understand the mother is no more, but
Yes,
she would have been able to find closure, because in 1976 when it occurred, then she had a lot of questions, and those
Yes.
questions were never answered until she departed this earth.
yes.
Okay, thank you.
JP Mlambo.
Judge Nkosi, it's me again.
Yes.
When you acted as DJP, did you have occasion to attend a meeting or chair a meeting of the PEEC?
Yes. I think it was the last meeting of our PEEC. I co-chaired it
I see.
with my colleague because I'm the chairman of the court performance committee. So I do need to know what is happening in the magistrate's court as well.
I see. So you co-chaired with your colleague, who's that?
Judge Hendricks.
Oh, okay.
Yeah.
My experience as JP in Gauteng is I always request the national statistics of the finalization of criminal trials. And there's a tracking tool that Department of Correctional Services has regarding awaiting trial detainees. In your meeting, did you have that report?
Yes, we did.
Am I correct that you realize that there's a perennial problem about the finalization of ATD-related trials in the regional courts?
Yes, there is a big problem.
Okay. So I'm asking you as an aspirant leader in the division, what do you think can be done to address that? Because you'd be the second most senior judiciary leader in the province, and you'll be cooperating with the JP to ensure that access to justice in the province is realized. Do you have any ideas how that can be addressed?
I think, as I said, effective and efficient case flow management is the starting point. They must bring reports to explain why there are delays. And if there are problems that the regional court is facing, to put our heads together to see how those problems can be resolved. Otherwise, if not, they're left to account as to why the matters are not being finalized, why time spent in court is low, that should also be explained to the president of the regional court, obviously, but he must then file a report to the PEEC to explain why the statistics are so low. I think one can take it from there, from the reasons that are given as to why the matters take long to be finalized.
Thank you very much. In terms of the perennial problem of the handing down of reserve judgments, or rather, before I go there, just a follow-up to the first one. This view that you're expressing now, is it a view that you hope to discuss, or did you discuss it with the JP after your experience in the PEC?
It is the view that the JP is aware of.
I see.
Yes.
Okay. And then in terms of reserve judgments, how do you think as an aspirant leader we can address this? Because it's a perennial problem. Taking account of the fact that we don't have judgment writing time as
Yes.
judges, you know that.
Yes.
And how do you propose we can deal with this?
Reserve judgments, I think the norms and standards tell us everything we need to know as a judge. Now, the only way to maybe is if judgments are reserved for a longer period, people's names should be made known so that the colleagues would know that you have judgments that we have not delivered. Perhaps after 6 months, then maybe we should remind the judges to finish their judgments and maybe to explain themselves as to why this judgment has still not been delivered.
Yes. Thank you, CJ.
Thank you, JP. I see that there are no more hands. We have reached the end of your interview, Judge Nkosi.
Thank you, CJ.
We thank you for coming here to be interviewed.
Thank
All
you.
the best. You're excused.
Thank you.
Colleagues, there is an error in our agenda, which I picked up only now. It makes no provision for deliberations for this session we've just completed. So I propose that we go into deliberations now because we're running behind schedule, then take lunch thereafter. Any objection to that proposal? No. All right, thank you. Shall we clear the room, please?